All right, welcome class. This is going to be your screencast lecture for today. So yesterday Friday, we stopped and talking about what's the legal definition of an arrest. How does the Supreme Court define an arrest, and what does it take in order to get probable cause for an arrest? So we talked about some of your due process and kind of what the Fourth Amendment establishes. Okay, so today we're going to talk about kind of the fruit of the poisonous tree. So what happens if arrests don't go as planned, or if the law enforcement kind of violates what should happen in an arrest? So any evidence obtained in violation of the Fourth Amendment is not admissible at trial. This is known as the exclusionary rule. All evidence obtained illegally is excluded from the trial. It's removed. Basically, lawyers aren't allowed to introduce it, and if it is introduced, juries are either nullified and a mistrial is declared, or we have to, the juries has to pretend like they never heard the evidence. So the purpose of the exclusionary rule is to deter police from misconduct. It forces police to do their job correctly, or risk having an entire case thrown out just because of one illegal activity. Okay, so take, for example, if the police entered your home without probable cause, and they found evidence that you're a drug dealer, right? They found marijuana, they found drug paraphernalia, such as a bowl or, a scale that has drugs on it, that you're used to measuring. All of those would then be thrown out of the case. In that case, the case would cease to exist. It would be as if that evidence never existed. We call that fruit of the poisonous tree, and so therefore your trial would be thrown out. You would get off scot-free. So that's also another example of how we err on the side of caution within our judicial system. All right, so what is the Fourth Amendment? Right? What's the actual language and definition of the Fourth Amendment? The Fourth Amendment is simply the right of people to be secure in their persons, houses, papers, and effects against unreasonable search and seizures. It shall not be violated, and no warrant shall be issued but upon probable cause, supported by the oath or affirmation, particularly describing the place to be searched, the persons or things to be seized. So essentially what that means is it's not that you can't be searched or seized without a warrant. In fact, most arrests and search and seizures happen without a warrant because probable cause is established in some other way. Plain view, a vehicle exception. There are lots of exceptions to the demand for a search warrant. But what it is saying is that when probable cause doesn't exist, police have to establish a search warrant. And those search warrants need to be very specific. They can't come into your house looking for drugs or firearms or a kidnapped child and find something else and then charge you with it. They would need to go back then and get another search warrant for those differing materials or those other illegal activities that they find, because they're not searching for them. It also establishes that you can't search for things that wouldn't necessarily be in the place you're looking for them. What that means is if you're searching for a gun, a handgun, you can't search in a drawer or like a cubby hole that couldn't hold that handgun. So those are the parameters of the Fourth Amendment, and that protects your due process of illegal search and seizures. So why do we have that, right? Like, the government has a lot of power. The executive branch, police forces, they have a lot of power and control over the population, right? If you've been pulled over or if you've ever had an interaction with a police officer, it can be a little unnerving. So the purpose of the Fourth Amendment is to protect people from unreasonable search and seizures. It protects privacy when nothing provides probable cause of criminal conduct. If you're walking down the street and you have a book bag, it doesn't mean the police can stop you and search your book bag whenever they want, however they want. That's not feasible. That's not how the government should work for and with the people. Because remember, popular sovereignty states that the people control the government, not the other way around. okay? Because we have a reasonable expectation of privacy against government intrusion. You don't expect the government to listen in on your cell phone calls, to read all of your emails, to gain access to your house whenever and however they want. We live different lives publicly than we do privately, and we want to protect those private lives. So it requires the government to normally obtain a warrant for search and seizures for persons or things. They can't detain you. They can't seize your material without justifiable reasoning. All right, that's what the Fourth Amendment's there to do. It's a very important amendment because it limits how and what the government can do when it interacts with us. So what can be searched for and seized? Well, people. Persons can be searched and seized. That's the definition kind of an arrest, that people can be detained, people can be sought out, found, and held even against their will. But there needs to be that probable cause. There needs to be justifiable reasoning for taking those steps. All right. So contraband, unrelated illegal items, anything that violates a civil or criminal law, anything that's used in a crime. Like a baseball bat is not something that's illegal to have, but police can search and seize a baseball bat if it's used in the process of a crime. So that's what fruits of a crime mean. So for us today, they're talking about if your cell phone is used to record something, that cell phone it can then be seized as evidence. Or if drug dealers amass lots of money during the process of selling drugs and they buy expensive cars and houses, those too can be seized and controlled by the government because those are fruits of a crime. So instruments of a crime and fruits of a crime can be detained and seized by the government. Mere evidence or other corroborating items. Your cell phone would be a good example of that. If you film someone else having a fight, the police can take your phone and use that as evidence. You can't just send them the video because that breaks kind of the chain of evidence. It can't be verified that that's exactly where it came from. So, understand that searches and seizures aren't just limited to small items. So what are the requirements for search and seizures? Well, with a warrant, they need probable cause to believe, A, that an item to be seized is connected with a crime. Okay, so they can't just seize anything they want simply because they think it might have been involved in a crime. They have to have actual hard evidence or reasonable suspicion that it was used in a crime. The item can be found in the place to be searched. All right, so this is, you can't search for, an elephant in a necklace box. Like, that doesn't make any sense. An elephant wouldn't fit there, so you can't go looking for things that aren't reasonably tied to that search warrant. The other thing we need for search warrants are probable cause. Information needs to be sufficient to the warrant. A prudent person's believe that the wanted individual had committed a crime for an arrest warrant, or that the evidence of a crime or contraband could be found in a search. Okay, so we either need reasonable suspicion, reasonable belief, probable belief to obtain a person or to obtain any information. This is what a search warrant actually looks like. And you can see that if you kind of go through and read this, it identifies specifically the location, what they're looking for, the person, what that person looks like, how tall they are, their weight, their name, their date of birth, where they're going to potentially find them, other people who may be involved in the activity. If we look at the next slide, it gives a specific list, an example of how they obtained that information, where the police officer got access to the information, which informed them of the scenario of the search warrant. Right? And that's really detailed out. It needs to be very articulated and specific. And then, of course, it has to be signed by a judge, documented, signed, and turned back over to the police. So this search warrant could then be executed. This is one from the state of Arizona. These are public information. They're published, and sent out. The public can research them, and they actually have to be turned over to the person or household that or any other item, dwelling that the police are going into. So they need a particular description of the place to be searched and for the things that are going to be seized. Very, very specific. Officers should exercise little discretion over what may be seized. They merely execute the warrant. All right? So if it's not on the warrant, they can't seize it. If it's not in the warrant, they can't search it if it's not a place to be specified. So it needs to be executed within a specific number of days. These search warrants are very limited. They don't just stand and last forever. Officers can only search in places and containers that reasonably contain the object of the search. Again, can't search for an elephant in a matchbox is what the Supreme Court has ruled. So once an item is seized, the search warrant is stopped. They may detain others during the search, but cannot search them unless named in the warrant. So let's say they bust into a drug house, and there's lots of people there. There's 5 or 6 people there, but the only name of the individual on the search warrant is the individual who owns the home. So they can detain those other members as a protection of safety for the officers. They cannot search them, but they can search the owner of the house who's on the search warrant. Now, they could go back and get search warrant for those individuals who are in the drug house because now there's reasonable suspicion that they may be buying or selling drugs in that dwelling. But those would each need to be issued as separate search warrants. So the exclusionary rule may apply if violations occur. So if they were to search one of those individuals who did not have a search warrant filled out for them, and they found something incriminating, they would then not be able to use that. So again, this forces law enforcement officers to do the right job, ensure constitutional protections are not violated. Now, there are several exceptions for a search warrant. Plain view, consent, stop frisk, motor vehicle exceptions, exigent circumstances, search incident to arrest, and special needs beyond law enforcement. What I want you to do now is you have a worksheet that I gave you last Friday that gave you several different examples. I want you to identify which scenario fits plain view, which scenario fits consent, stop frisk, so on and so forth. So you can use the rest of your time to research what those exceptions to a search warrant are and then match them with the correct scenario that I gave you. So I hope that goes well, and hopefully I'll see you guys tomorrow on Tuesday. If not, have a happy Thanksgiving, and can't wait to see you after Thanksgiving break. Have a good day, guys.